day, viewers. We are back on our weekly legal literacy series, and today we shall be taking on the topic inheritance, custom law, and justice. Do not mind or how the topic has sounded. What we simply want to discuss today is how property devolved from parents to children. That is, how to, or the process of property transferring from deceased parents to their children. That is basically what we want to discuss under today's topic. Basically, we all know that when either the two parents die at a time and they've left a will behind, that is what the law calls dying testate. Dying testate. Then there's no much problem as to how the property owned by such parents devolve or are transferred to the children. But problem usually arise where a parent or the parents die intestate. That is, they die without leaving behind a will. Now, it has always been our advice on this program to tell our viewer that it's always good that as you go about life, as you go about acquiring anything in life, make sure you have a will in place. And that will is in that will you are going to really tell or say how that property or that in which you have acquired will devolve to your children or to whoever at death. And it makes life and a whole lot of things easy for people you are leaving behind at death. But where this does not occur, or where this is not the case, usually problems are left behind for people who survive such ones. And so this morning we're just going to discuss basically how property of a deceased parent or parents devolve to their children, or how the process of inheritance or takes place. Now, in the past, there's usually this thing popularly called illegitimate children. We're going to also look at that vis-a-vis a legitimate child. Now, basically, a legitimate child was seen or is still seen as a child that is born to parents that are legally married, whether a marriage under law and custom or marriage, a statutory marriage. Now, under either of these two types of marriages, a child that is born is usually regarded as a legitimate child. But where a child is born to parents that are not legally married, then such a child is popularly referred to as an illegitimate child. And usually in the past, there was always a problem for an illegitimate child or the so-called illegitimate child when a parent dies without a will. Because it was always difficult. I mean, legitimate children that are born within wedlock, will always want to see such a child as a foreigner, as being outside of that marriage and never regarded as being part of the family. But we thank God over time, our laws have intervened to correct a lot of things. And so this correction and where we are coming from is how to discuss what viewers know about or in summary this morning. Now, the position of the law is that customarily, even where a child has been born outside marriage, but the father acknowledges that child within his lifetime, then that child automatically or becomes a legitimate child, so-called. I repeat that. I say customarily, under customary law, even where a child is born outside wedlock, outside marriage. But the father goes ahead, the man who is the father of that child, or is the biological father of that child, goes ahead to acknowledge that child, paternity of that child, that he is the father of that child. For example, if he goes ahead to tell any member of the family, any elderly member of the family, to say, oh, that child belongs to him, that he owns that child, or that he is the father of that child, then that child will be regarded as a legitimate child, so called. So, which means even where a child is born outside wedlock, but that the father goes ahead to acknowledge the paternity of that child, then the child becomes legitimate. It's no longer regarded as illegitimate. And so, even in the old system, that kind of a child who can legitimately inherit whatever that father has, or whatever belongs to such a parent or parents. So that was what the system was. And so the system as it was in the past was working a lot of injustice. A lot of injustice in the sense that if, for example, a child is an illegitimate child whose paternity was not acknowledged in the lifetime of a man, then that child will find it so difficult to be able to inherit anything from that child. What I mean by that is simply this. Now, when a child was born outside wedlock, and the supposed father of that child, or the real biological father of that child, is unable to acknowledge the paternity of that child in his lifetime, strictly that child will be regarded as an illegitimate child. And what becomes the fate of that child is that that child will not be able to inherit from that father. That was the kind of hardship that the position of law or customary law worked in the past. And the same way in the past, a child born outside wedlock, even where his paternity has been acknowledged, and that man who is acknowledging the paternity of that child is into another statutory marriage, that statutory marriage will never admit of another marriage, or will never admit of the paternity of that child. And so that child will not be able to inherit where another statutory marriage exists. So that was the whole lot of injustice that our law worked in the past. But the good news is that since the intervention of the 1999 Constitution, specifically Section 42 of the 1999 Constitution, the whole position of the law has changed. In fact, the law, specifically the ground norm, which is the Constitution, has intervened to change a lot of these things. And so, from that point onwards, whether a child is regarded as a legitimate or illegitimate, that child, as long as it could be established by any evidence that the child is the child of the deceased man or woman, parent or parents, that child will legitimately inherit from that parent. Even where in the lifetime of that man, the paternity of that child had never been acknowledged. For example, if the child has been able to adduce a DNA evidence that he enjoyed or the paternity of the deceased man or woman, then that child will be able to inherit from that or parents, or parents as the case may be, by virtue of section 42 of the 1999 Constitution. And what is that special thing about that section? That section is the section that prohibits all forms of discrimination. Discrimination on the basis of sex, discrimination on the basis of the circumstance of the birth of an individual, or discrimination on the basis of religion, circumstance. In fact, anything that can come to mind, that any form of discrimination at all, honestly, can conveniently fall under that section. And our courts have been so good, they have, even the highest court of the land, the apex court, which is the Supreme Court, had the opportunity at two or more times to actually decide on cases based on or the subject matter of inheritance. And so mainly and to the advantage of everyone, in the case of Ukeje and Ukeje, which was a very recent case, the Supreme Court decided that there any law that discriminates anyone on the on the basis of the circumstance of the birth of that person or on the basis of sex cannot stand. And so by virtue of that pronouncement by the Supreme Court, which is a pronouncement on Section 42 of our 1999 Constitution, every obstacle that existed on the subject of matter of inheritance on the basis of the circumstances of birth, on the basis of sex, had been taken away. And so from that point, a child, whether regarded as legitimate or illegitimate, as long as there is an evidence linking him to the deceased, to being the child of the deceased, can inherit from the deceased, even where no will exists that apportions any part of the deceased property to him. It means the child can legitimately inherit from the parent or parents. The same way, any child, whether a male or a female, can legitimately inherit any form of property from a deceased parent or parents from that point. And so what law has come to do here is to come and restore justice, is to come and restore fairness over and above what it used to be customarily. And so by that decision, for example, the customary practice among the Igbo brethren, for example, in Nigeria, where females are always disinherited, are not allowed to inherit or property from parent or parents, deceased parent or parents, have been declared to be unfair and can never stand in the face of Section 42, both 1 and 2 of the 1999 Constitution, and as interpreted by the Supreme Court in the case of Ukeje and Ukeje. In that case, it has been established that females have rights to inherit land or any form of property from their deceased parent or parents. And by parent or parents, we mean both father or mother. Father, mother, or both. Female children, as well as male children, can inherit such property, even where no will exists, even where the deceased has never left a will behind. That is, even where a deceased has died intestate, then a child, both female or female, a child both legitimate or illegitimate, not minding any circumstance, can, from that point, inherit property. So that is the little I want to discuss with you this morning. And we're going to be back next week to still further this topic and extend it to another subject matter. Till we come your way, thank you and bye for now.